Good evening, everyone. So today I will be discussing the primacy decision for husband and father. So the family code of the Philippines. So it is an executive order 209 signed into law by Carson C. Aquino on July 6, 1987, and with which became effective on August 3, 1988. So for Article 14, so in case either or both of the contracting parties that having been emancipated by a previous marriage are between the ages of 18 and 21, they shall, in addition to the requirements of the preceding article, so exhibit to the local civil registrar the consent of their marriage of their father, mother, surviving parent or guardian, or persons having legal charge of them, in order to in order mentioned. So such consents shall be manifested in writing by uh, interested party who personally appear before the proper local civil registrar, or in the form of an affidavit made in the presence of two witnesses and attested before any official authorized by law to administer oaths. So the personal manifestation shall be recorded in both applications for marriage license, and the affidavit, if one is executive instead, shall be attached to the said applications. So, for this article, it, it, it was trying to said that um, that in the law, uh, 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 law is explicitly partial to the father's decision to give or withhold consent to the marriage of a son or daughter. So if the mother consents valid, uh, um, but the father objects to the marriage, so there is no valid consent. So on the other hand, so even when the mother have serious objections to the marriage, so the child's father could decide otherwise, and the mother's reservation will be left unheaded. So we are done for Article 14, so let's proceed to Article 96. So Article 96, so the administration of the enjoyment of the community property shall belong to both spouses jointly. So in case of disagreement, so the husband's decision shall prevail, subject to recourse to the court by wife for uh, proper remedy, which must be availed within 5 years from the date of contract implementing such decision. So, Article 96 says that um, if the husband and wife are living separately from one another, and one of them sells property without the consent of each of uh, to the other, so the sale is void. So for Article 1 to 4, the administration and enjoyment of the conjugal partnership shall belong to both spouses jointly. So in case of disagreement, the husband's decision shall prevail, subject to recourse to the court by the wife for proper remedy, which must be availed within 5 years from the date of contract implementing such decision. So, for Article 124, So in the event of the spouse is incapacitated or otherwise unable to participate in the administration of the conjugal properties, so the other spouse may assume sole power of administration. So these powers do not include disposition or encumbrance without authority of the court written consent of the spouse. So in the absence of such authority, so the disposition or encumbrance shall be void. However, the transaction um, shall be controlled as a continuing offer to the part of consenting spouse, and the third person may be perfected as a binding contract upon the acceptance by other spouse or authorization by the court before the offer is withdrawn by either or both offerors. So, for Article 211, so the father and the mother shall jointly exercise parental authority over the persons of their common children. In case of disagreement, so the father's decision shall prevail unless there is a judicial order to the contrary. So, in this article, it says that children must must obey, must respect towards their parents, or shall we say, they were obliged to obey since they are um, since they are under the parental authority. So they must show respect towards their mother and father. So for the last Article 255, the father and the mother shall jointly exercise legal guardianship over property of the emancipated common child without the necessity of the court appointment. So in case of disagreement, the father's decision shall prevail unless there is a judicial order to contrary. So for example, when the market value of the property or the annual income of the child exceeds 50,000. So for example, so the parent concerned shall be required to furnish a bond in such amount of the court may determine. So but not less than 10% the value of the property or annual income to the guarantee the performance of the obligation prescribed by general guardians. So that would be all. So I am done discussing to you the Article 14, Article 96, Article 124, Article 211, and Article 255. So thank you everyone. I hope you've learned something from my discussion, and have a good day. Thank you.